I don't know what bundle you have in front of you, but we can work with the bundle that we've received, and if we have any difficulty, we will deal with it then. If there's any document that you wish to refer to, we will identify such a document and it will then become part of the record. I think that's the best we can do today. So if you are in a position to carry on with your evidence, the tribunal would like to continue, Judge Makhubele.
Thank you, President.
Sorry, Chair.
Yes, I agree. Some of the bundles.
I'm sorry,
For
I think-
instance, JM1.
Sorry, Judge Makhubele.
Chair, just for some clarity, we've received the bundles that were presented to us yesterday, and we've got JM1 and JM2 that we dealt with at the previous hearing. Just for clarification, are we going to be using the new bundle today, or are we going to be using the old bundles? Because as you indicated, some of the documents in JM1 and JM2 have been repeated here. But the danger with this new bundle is that if you look at JM2, there are certain emails that are there, but you cannot see them in JM2 of the new bundle. So there's a bit of a problem with regards to seeing certain documents, and there may have to be a referral to the old JM1 and JM2. Thank you, Chair.
President, can I respond just with regard to JM1 and JM2?
12.
What happened? Oh, the code. Okay.
Yes, thank you. Judge Makhubele, I think the issue that's been raised by the evidence leader is that some of the documents which you gave and that's been put into a bundle today, we've already have, namely those labeled as JM1 and some of those that's labeled JM2. I don't think it's going to be possible, as requested, that we deal with the old bundle because you've got a new bundle in front of you, if I may ask you, the one that you have given to the OCJ.
Yes, that's the one. I was trying to explain that we've been talking by telephone. The state attorney is trying to familiarize herself with this, and I've been sending documents to compile bundles. JM1, you already have it. And JM2, you already have it. What I'm saying is I've already looked at JM2. The font is so small you can hardly read. But it's a bundle that is in your possession, President. And I've already dealt with JM1 and handed over what I needed to hand up. So we do not need to focus on JM1 today. And JM2, I had already started to give evidence on those SMSs, and the bundle is in your possession, and I would suggest that we use the bundles that we already have, that I submitted on the 26th for JM2.
So as far as you're concerned, as far as further evidence from you are concerned, you'll be focusing on what we have today marked from JM3 onwards. Am I correct?
Yes, I didn't finish JM2. I will first finalize JM2.
Yes. If I may then put it this way, what we have in front of us today, we will simply refer to that as the respondent's bundle.
Yes.
And that is the bundle that's been made available to us today. And we will use that then as it concerns your evidence, and we will refer to it as the respondent's bundle, JM, etc., whichever you refer to. Will that suit you? Do you understand?
I do, President.
Yes, then we will continue. Thank you. Yes, you have been sworn in, and the further evidence you will give will be further evidence in this hearing as such. Yes, Judge Makhubele.
Thank you. Because with regard to JP Mlambo, there's JM2 and JM3, and I want to deal with them at the same time. There's an issue that I raised with regard to the neighbor, and I was asked about the dates. I have compiled, it's a small bundle, it's 8 pages. It's those are SMSs JM4, so that I don't get back to it, because it's just to conclude what I undertook to do. JM4, It's, I already gave a date when asked by Judge Mushidi that the date is September 21, 2017, and he gives me his email address. Then I respond and tell him that I will send the CV, and I sent on that day. He responds that he got it and he forwarded it. Our next communication was in that small bundle, 3 pages down the line, July 4, 2020. It's communication in Xitsonga language. I don't know if you will get someone to translate, but I can give a translation that I assure you that it's correct, but you can verify it.
No, it's fine.
Mr. Chairman, it's Judge Mushidi. Judge Makhubele, I don't recall the question of the communication between you and your neighbor being ever contested in these proceedings. That you're approached by a neighbor and he told you about the position at Prasa. I don't think it's in dispute, really. And that you gave him your CV and you left it at that. Is that not so? Am I misreading the evidence?
Thank you, Judge Mushid. You are not misreading the evidence. There's no contestation. This same evidence I gave at the State Capture Commission, because there was an allegation that it was by Advocate Botes, but surprisingly he didn't testify about it here. So I will also leave it because he did not testify about how I went to Prasa. But this was intended to challenge that narrative that my going to Prasa had anything to do with state capture or anything. The next documents is just me, just before I went to state capture, telling him that his name is going to be, I'm going to mention his name. So he was apprehensive and he said, but why don't I call the department to testify? And I said to him, I know that I gave you my CV and you said you took it to the department. So the investigators, whoever wants to investigate this matter further, has that information from me. And they can ask me for your details, and to the best of my knowledge, no one has contested this. Thank you. I will not go through each and every SMS exchanged between me and Judge Mlambo. But the reason I went this route was to show that in our communication of almost a year, because the date starts December 14, 2017 to 29 November 2018, there's nowhere where he tells me, particularly in beginning of term 2018, that he called me, why am I not coming to take an oath? And instead, when you read all these SMSs, it's a person who has already made his decision, he has submitted his request to the president, and he is not going to do anything about me working as a judge until he hears from the president. So by saying this, I'm disputing this evidence that I was called to come and work, I refused. When you read these emails and some of the letters, I actually tendered my services when I realized that the president was taking time to amend the date. I said to JP, why don't you let me work with that certificate? And he kept on saying it's invalid. And if you must work as a judge, it means I must appoint you as an acting judge. And that was his attitude. And when you read the letter that he wrote to Minister Masuta, he clearly tells him that JP Mlambo, has directed the administrative staff not to capture my details in the PESAL system. And so I'm just wondering at what stage. You cannot blow hot and cold. It's either there is this version that he wanted me to work, or he waited for the president. And when the certificate came around, I became apprehensive towards the end of March. And I asked him, JP, what's supposed to happen to me on 1 April? I have complied with, because remember, if you look at some of the emails and SMSs, the only meeting we have with Judge Lidwaba was on, I think, 12 or 14 March. And that was in preparation for my coming, beginning of April. Because at the time, JP Lidwaba was preparing the recess roster, which coincidentally started on the same day as 1 April. When we left that meeting, I was certain that I am going to start on 1 April, but after that meeting, that's when JP changed his mind and said he cannot appoint me because he's waiting for the president. The rest of the emails...
If I may just interrupt Judge Makhubele. I think the crux of the complaint is that he had asked you to commence with your duties as a judge in January of 2018, and you did not start in 2018, and he only heard, according to Judge Mlambo, that he raised with you your appointment at PRASA in the middle of January 2018. Before that, he didn't raise it with you at all. Now, your evidence is different, isn't that so?
That's so, President.
Yes, and we have your evidence, and that really is the crux of the issue. On Judge Mlambo's evidence, he was confronted in the middle of January with the information that you could only start later in that year, and I think it was in April. But the complaint against you, the first complaint, is that you really didn't take up your appointment in January 2018. And according to you, Judge Mlambo already knew that you weren't going to take up your appointment on the 1st of January, whereas his evidence is to the effect that he only learned somewhere in the middle of January that you were not prepared to start in January 2018. That basically is the two versions that we have. As to what happened after that, much of it is really common cause. And it has, in my view, really nothing really to do with the first part of the complaint against you. I hope I've made myself clear. So what happened after your meeting in January 2018, you say you met with Judge Mlambo alone towards the end of January 2018. His version is that he met with you in January 2018, but he was with the Deputy Judge President. You say no such meeting happened. Am I correct?
President, the emails, if you can just, because
No, I'm not- no,
I
sorry.
have to give you a date of the meeting invitation.
No,
That was sent to Judge DJP Lidwaba for us to meet. It's here
Yes.
in these emails.
No,
that's-
I can understand.
We are in agreement that there was just one meeting, and that meeting was in March,
Yes, that's
President.
what I'm getting at.
not in January.
Yes, I understand that. We have that evidence.
Yes, but the other thing I need to correct, if you're going to allow me to go through JP Mlambo's evidence in chief and under cross-examination, somewhere he admits that he became aware that I was at PRASA in December of 2014. I was reading his evidence again. And that's in line with what I said, that when I went to see him after my request to meet him I think the request is by, this is one of the requests, the face of this JM2, but then we had other meetings before this. So in December, JP knew about PRASA. It is in his evidence. I will specifically refer to it if you will allow me an opportunity to challenge specifics of his evidence in as far as it may be material to the complaint. But the other thing that I want to, as you guide me, remember I'm not represented. If I was represented, my counsel would be leading evidence in the manner that he has prepared, and you will be fighting with him. Is that relevant or not? But now I'm the legal rep and the affected person, so I have to think what is relevant or not. What I need to, as you guide me on what is relevant or not, I've quickly looked at the JCC decision and also the JSC transcript as to what exactly you are required to make findings on. I've also looked at the terms of reference. There's a bit of a disconnect between the terms of reference and the decision of the JCC, which the JSC actually just, the one question that was put to the members was, are we agreeing with the JCC to establish a tribunal? And then there were two major submissions, one against and one for. And the one for was simply saying, let us endorse the decision of the JCC. The JCC, paragraph 3.1, the question that is supposed to, if my reading is incorrect, you will correct me, but paragraph 3.1 says, whether she, meaning me, should have continued at PRASA as chairperson of PRASA before revocation of her appointment, President. So for the JCC, that's the issue. They are not, I cannot say they are not concerned, but then the issue, that's the issue for them with regard to the first complaint, acknowledging that there was a request to revoke or to redetermine the date of appointment. That was the question, and that's the question that you must decide. Should I have remained at PRASA after JP Mlambo sought redetermination or revocation of the date of 1 January 2018? So I think if my understanding is correct, President, at some point you will have to answer that question, which is why for me it's important that I deal with why because when I read this, it means after JP Mlambo wrote to the minister on 22 January, I believe, 2018, I should have not done anything. I should have waited for the president for 6 months. So, well, that's an issue for argument, but I'm saying, allow me to say something.
Yes, please, then just carry on with what it is that you wanted to commission to take into account, Judge Makhubele.
Thank you. At no stage, after JP wrote to minister and by extension the president in January, was I told that I must resign from PRASA or not do any work. You will recall that his letter to the minister says the date of 1 April, she would have resigned from all positions. So that was my understanding, that simultaneously as I resign from the Water Tribunal, I will also resign from PRASA. And, but the factual situation is I didn't stay at PRASA until the time that I intended to. I resigned on the 16th of March, 2018, and this was after a meeting that I held with JP Mlambo and DJP Lidwaba to the effect that I must start preparing for my assumption of duties on 1 April, and in that regard, I should do recess duty. And if there was any mention of why are you not leaving, that must have been the day, because after my meeting with them, which took place on 14 March, I went to put in my resignation at the PRASA, and we spoke about many things. Have you, other than the CIR matter, has the board made any other controversial decisions that we should be aware of? And my answer was no, we have not done anything, we have not presided over any tenders, because immediately, soon after the appointment of the board, there was a challenge as to the the status of the board. You remember there's that case at the Western Cape. So basically, there were no controversial decisions, controversial as the complainant would allege, other than the one that suspended the panel and on 1 December 2017. With regard to issues about matters that were before the court litigating, and that was discussed in our meeting with the DJP, that am I or was I involved in any of the matters that are before the court? And unfortunately, I have never been involved in any of those matters that are under litigation. So the short answer to this question is that at no point was I told that an application to redetermine my date means that I must just sit and do nothing. I've already testified that I had other matters where I was appearing as counsel. I continued to work at the Water Tribunal, as you will see from JM5. That I'm not going to take you, don't be intimidated by the volume. I'm not going to take you through each and every document in JM5. The purpose of submitting this is to indicate that even when I went to the interview, before actually, we had already started to set down matters for hearing at the Water Tribunal. The face of JM5, that's an email from me to the registrar of the Water Tribunal, where I forwarded a schedule of hearings for until end of December of 2014. And as you can see, this was the first one. The second one, updated one, shows who is the chairperson. But we worked until end of December, finalizing the matters that were in our roster. This, the purpose of these emails is just to indicate that I was very busy at the Water Tribunal because there was an allegation or some suspicion that came out that I actually didn't even do anything at the Water Tribunal. And this is to show that from October to December, I was hard at work. And JP Mlambo said the duties at the Water Tribunal are administrative. They are not administrative. As you can see, I've attached some judgments. For me, as chairperson, firstly, I can say my functions are more like maybe JP, what JP and DJP do. I would read the files and allocate in terms of the expertise of the members of the tribunal. I would also chair some of the appeals. My last appeal, you will see from these documents that I'm not going to take you through, but if there's any doubt, there is everything here. My last appeal was towards the end of March, where you will also see there's an email that I wrote to a colleague to say he must chair that particular tribunal because I said if it's not finalized, I should be able to simply step out. You will also see that some of the functions for me as chairperson involved, after reading the files and maybe allocating the matter, I would also case manage the particular appeal by giving directives on how the matter should proceed, the kind of information that should be placed before the panel, before it's heard. So it was not a simple kind of an admin role that you just go there and dish out files. And for me, that's the reason why I said I want to resign. And to resign, I can't just resign overnight. I'll need, and then we settled for April. But you'll see in the emails.
Just before you carry on with the Water Tribunal, just to remind you that Judge President Mlambo said that that wasn't quite an issue. You did tell him that you were sitting on the Water Tribunal, and he said to you that, well, you can continue sitting on the tribunal even if you start your duties as a judge. Did that happen or didn't it happen? And if it did happen, when did it happen? Can you just assist us there?
Pardon, what's the question, President?
Well, when did you and Judge President Mlambo discuss your sitting on the Water Tribunal?
When I was completing the questionnaire?
That would have been in around October 2017 or September 2017.
No, the closing date is much earlier than...
Sorry, when?
The closing date is much earlier than the date of interviews. The closing date is, if I remember well, in that particular round of interviews was sometime in June of 2017, because they allow a period of all those comments and setting up. So it was much earlier.
And you told him about your position on the Water Tribunal?
Yes, I told him.
Yes. No,
I told him that.
He gave evidence that you did tell him, but you say it was in March 2017.
No, I'm not saying much. I say as I was completing the questionnaire.
And when was that?
The close, I don't know. I don't have it with me.
Okay.
But what I know is the closing date was around June of 2017. And when you look at the transcript of his evidence, he mentioned many meetings. Although he never tied himself to a number, he just said many.
No,
More than 3 meetings, but we spoke about it a lot. And when I, in December, after he issued the directive, and I then wanted us to talk, and then he then told me why. He said everyone must start on 1 January, and then I still said, but I can't, because now I need to resign. I have not resigned. I still have work. Why did you not tell me that our arrangement was not going to work? And that's when he set on a journey to revoke that date.
On that issue, I just want to get clarity. That's all. You had a discussion with Judge President Mlambo in December of 2017. That's correct. You had a discussion with him. That was his evidence. That's been your evidence. It was around the 14th, 15th of December.
That was not our first meeting.
No, I'm not talking about your first meeting.
Yes, the last. Our
Yes.
last meeting was, I said, looking at this.
No, I just want the date in 2017.
The last meeting we had was a day before recess or on that particular day, I cannot remember.
Yes.
That
Well,
was
we know
our-
it was in the middle
That
of
was our
December.
last engagement,
Now, let's just concentrate on that.
yes.
On that date, that is December 2017, the last meeting you had with him, can you recall whether your position at PRASA was discussed, yes or no?
It was discussed,
It was discussed.
yes.
And in that discussion, was Judge President Mlambo, according to you, made aware that you can't start on the 1st of January 2018?
That was the purpose of our meeting.
Right.
And,
No,
and-
so
and
before,
that's-
no, I just want to know, according to you, before the 1st of January 2018, you've had a discussion with Judge President Mlambo. That is the December discussion we spoke about now. And he, according to you, was well aware that you could not start your judicial duties in January 2018. Either yes, he knew, or no, he didn't know.
That's correct, President. I've already testified about that.
Yes, no, I just want to get clarity.
Our next
No,
meeting-
before we go on to the next meeting, just let's stay at December. You already had informed him that you can't start, or he already knew that you can't start in January 2018. Is that correct?
That is correct.
And the reason for that was because he knew you had taken up a position with PRASA as the chairman of the board. Is that correct?
Amongst other things, there was
No,
a
no,
water
I'm just
tribunal.
interested in that. I'm just interested in the PRASA.
President, if you want to bottle my answer like that, it is as if, because if you read his evidence, he says there was this main reason that we had already discussed of the water tribunal, but then there was the PRASA thing. And I say also the other matters. So you cannot say because of, as if that was the only reason.
I'm just interested, was PRASA, amongst other things,
Yes.
discussed
Yes,
in December?
yes.
Well, that's all I want to know. Because he said, now, he first became aware of it and he raised it with you in January. You say that's not correct. He already knew.
The record
No,
of
I'm
his
just
own
saying.
evidence will support what I'm saying.
Yes,
because
that's fine.
he says he knew about PRASA in December, but then on the other hand, he says him and DJ Pili Dwaba had to extract it from me in January. So it's a question of
Yes.
which statement from him only. But I'm saying by December, when I left his office, that last day, we already had agreed on the way forward, that he was going to write to the minister. I do not have to report on 1 January. He's going to redirect the files. And then he started writing to the minister, and he, so I never, even because I was not expected, let me put it that way, I was not expected on 1 January, and I've already said, no one called me in the first week of January to come and take an oath. And in any event, how do I take an oath when I don't have a certificate of appointment? Because he had already returned that certificate. Appointment, take an oath as what? As an acting judge. And I'm not aware of anyone taking oath during recess. First week of January, second week of January, and I still maintain I did not receive any calls from JP Mlambo or DJP Lidwaba because people are taking oath. This I saw recently in the media. There was a court sitting specifically for taking oath of newly appointed judges. That's a new thing, probably to where there's a mischief, you change the policy and how you do things. That's a new thing, that where families sit in court and newly appointed judges take an oath. But for me, it didn't happen, as it says. And for me and him, we finalized in December, and the next time we had a communication, it was after the complainant had written to him, and we then met thereafter.
Yes, we have that evidence. Thank you, Judge Makhubele, but please carry on.
So I can't say I'll take your advice, but I'll take your noting that there's no issue that I was at the Water Tribunal. And because, as I say, President, maybe sometimes I confuse evidence that was, or statements that were made at State Capture Commission, because the commission even went to the Water Tribunal. I don't know who they spoke to, because the only thing I saw were copies of my 2017 invoices, but I didn't get a chance to go back to the commission after, because they abandoned their investigation. But so yes, I was very active. There's a wealth of evidence here, so I will put this aside. And the next thing I can talk about to close the issue of so JP Mlambo never called me to say, I'm talking about after our meeting of 30 January, to say, now here is a complaint, come back and work. Instead, he writes that letter to say she will resign from all positions. So that's my evidence, President and tribunal members, that I was never told to sit at home and not do anything. And at that time, as a person that's self-employed, you need to pay your bills. So I don't know what the suggestion would have been, that here, on the one hand, JP is refusing to allow me to work, and here the president is taking 6 months to make up his mind. Then I should have just sat at home and do nothing. I don't think that's fair. I'm looking at I know we started late because for whatever reason, but are we having a tea break, or will?
No, we can if you would like. Are you moving on to something else? Is this a convenient stage for you?
Yes, I will, unless if there's something you want to take up with me on this issue, as I said, I'm not going to go through each SMS, each email. I will take
And do
your
you need?
guidance, otherwise I'll move on to the next
Yes.
issue, which will be, I'll just specifically direct you to JP's evidence on issues that are material to this, what I'm talking about. And then I will then move to deal with the evidence with regard to the second 3.2 in the JCC decision, 5.2 in the terms of reference. That's the issue of PRASA.
Well, we'll then stand down for 15 minutes and you can have some tea or coffee and come back and we will deal with the issue you have last mentioned. Thank you. We will then adjourn for 15 minutes. Are you ready to proceed?
I didn't realize you were already in. My apologies. Thank you, President and Tribunal members. I was not able to read the transcripts and such that I can point out to the dates, but I have extensive notes that I've made, but should it become relevant in oral submissions, I will do likewise. I said I'm going to deal with JP's evidence before the tribunal. In his evidence, he didn't want to pin himself to a specific date or time or anything. For instance, he was asked if he met me, and his response will be, because it was put to him that Judge Makhubele is going to say you met at your office, and he couldn't deny that we met. So I say we met. I've already testified about that. And the next thing, this is under cross-examination. He was asked when he became aware that I had accepted Brasa chairpersonship, and his answer was around December. This on record. I said I will look it up, and here it is. It's on record. And he also says he got this from me in December when he was with DJP Lidwaba. They had to extract from me, and I'm saying it was me and him only. DJP Lidwaba only got involved in this matter in March, as I've already indicated. There's an email invite for a meeting between me, him, and DJP Lidwaba.
Sorry, can you just give us the date of that email?
The email?
Well, the one that you referred to.
There's an email from where in fact, he is the one that starts to ask me for a meeting because he had what he calls a meeting with Minister Masuta. And then his PA arranged that meeting where DJP Lidwaba was invited. That was in March. I wish my attorney will look for it. Okay, here it is. The emails that I have are not properly paginated, but it's an email of 14 March 2018 from Naledi Ndungane. Naledi was JP's PA as far as I recall, and it's directed to Mlambo JP and me. In the actual invite, which is a MIME attachment, these emails is not properly transcribed, President. You'll pardon me. I'll ask my attorney if she has it, this email invitation that was sent to the three of us for a meeting. This is,
Sorry, on what page are you of this paginated bundle? When you refer to the email of the 14th of March?
JM3. Give me a moment, President. These are emails in JM3. JM3 in the bundle handed that you received is item number 3. And the page 5, they go backwards, but at page 5, page 4, no, that's something else. This page 4, it's January, we're looking for 12 March, bottom of page 4. And that's me, subject re-outstanding judgment. I had replied to, he had asked about an outstanding judgment, and in my response, I requested to see him about other things. And top of page 5, good evening, JP. I'm waiting for confirmation of our meeting tomorrow. However, I've seen that you are in Johannesburg according to your schedule, Nana. Then the bottom email, it's from him, noted, thanks, Nana. Could we meet on Tuesday if convenient? I had a chat with Minister Masuta about your situation. Please indicate what time would be convenient for you. And I also reply, I don't know which reply came first. Can you just pardon me? I'm looking for the meeting invite from Naledi Ndungane. It was not printed. Can we make a note of it? There's an email invite for the meeting of 14 March. I think President will have to, my attorney will have to do better with these emails because they are not making sense.
You understand the email that we are looking for. It's the one calling for a meeting where you met with Judge Mlambo and the Deputy Judge President.
Yes.
That's the email we're looking for.
That's the email I'm looking for.
Yes, and you say you press for time now to find it. But when you find it, can you please let us have it?
I think what we must do when we adjourn here, we must, because some pages is just forwarding of the same email such that there's nothing in a particular page, but the gist or what was intended here, it's emails between in this month of March where we meet with DJP Lidwaba and also the discussion about the minister and the letter that he wrote to the minister and my email to him. So they are not here. I don't know what happened, President. I'll just make a note that we need to rearrange JM3 before my cross-examination.
Yes, certainly. I think the evidence leader has something that she wished to draw to my attention.
Thank you, Chair. If you go to JM2, I'm not sure whether, just to assist Judge Makhubele, I think they're on page 5. It's just that it's a small email there.
Page 5 of JM2.
2.
I see in JM2 they've also, yes, these are SMSs, Ms. Erse, but it helps. That's the meeting. There was also an email confirmation. Hi, Nana, it's, oh, my eyes, March 14. Hi, Nana, the meeting is confirmed for 13 hours in my Pretoria chambers tomorrow. And this was also followed up by the particular meeting invite that I'm talking about, that we met with DJP Lidwaba and about my starting in April. And after this, well, we know I didn't start.
Sorry, I'm lost, Judge Mushidi. I'm lost. Is that the meeting where, on the evidence before us, DGP Lidwaba said to you, it's not too late to leave PRASA. You can still come and work. Is that the meeting you're talking about?
I do not recall the evidence. Was it JP Mlambo?
Yes, this is JP Mlambo's evidence that he was with his DJP and knew when JP Mlambo tried to persuade you to start, you said you would not start. And the DJP then said that it was not too late for you to start. That is what I recall, what was said by the DJP. Now, what is your recollection of the meeting you had where the DJP was present?
Thank you, President and Judge Mushidi. The problem that I have with the evidence of JP is the extracting of information from me, according to him, happened in December of 2014. But I'm saying the one meeting that we had with DJP Lidwaba was this one in March of 2018, where we were planning for my assumption of duties on 1 April, and where we also agreed that I was going to start with recess duty because DJP Mlambo was compiling a recess roster. That's what we agreed on, that I would start on 1 April. But after the meeting, JP Mlambo changed his mind and wrote to the minister to say he is not going to do anything about me until he hears from the president. So there were no 2 meetings. So, because according to him, he extracted the information from me in December. And I'm saying there was no meeting with DJ Pili Dwaba in December. The December, it has always been
No,
me
no.
and him. He only involved DJP.
I think his
Lidwaba.
evidence, no, sorry, I think his evidence was
Yes, thank you.
that the DJP was present at a meeting in January. Did such a meeting occur or didn't it occur?
It didn't occur. So that's my evidence about the evidence of JP Mlambo. There are a lot of issues that were put to him is the law. When does one become a judge? I have my, so that I believe it's an issue for argument. And but on the facts, that's my before then, the last question he testified under cross-examination that he arranged for the acting judge. The acting judge started when term started. So there couldn't have been the 2 of us, and besides, I didn't even have a certificate. Thank you. That's in as far as JP Mlambo is concerned. The other evidence that I want you to take into account was put to him, but he was not in a position to confirm, but it's not in dispute that the official responsible for the register of what do they call it? Conflict? Registrable interest. Yes, wrote an email to me to say he has been informed that I'm only starting in April, and as such, I must not submit that form. So I don't think it's necessary to call him to come and say that there's no dispute. That's what it was. And if becoming a judge, it's the jurisdictional factors, one would say, in terms of the various legislative prescripts. And one of them is this. And Unless if the panel has anything to ask me about the first charge.
Please carry on. If the panel has any questions, we will deal with it at the time the evidence leader is finished with her cross-examination. But meanwhile, you may move on to other matters that you want to testify, Judge Makhubele.
And before I move on that, because the issue of dual status, and in terms of what you are required to make findings on, factual situation, I did not sit as a judge. I did nothing of those things that are required for one to be a judge. I did not sit, I did not take oath of office, I did not take a salary, I did not, and even on JP's evidence, I was not in the system. And assumption of duty is an administrative act and he as head of the office, if he says, I'm not capturing you, and that's what happened. I only, when I received my appointment in May of 2018, with all the letters from the president, the minister, I went to take an oath of office before DJP Litwaba, I remember, and then I was put in the court roster. So for all intents and purposes, and the intention of everyone involved in this matter was that the date should be redetermined, and that's the prerogative of the president. He exercised that discretion, and I cannot have two appointment certificates. Actually, the first one, I have not even seen it, whether for memory's sake or anything, I don't even have it. I don't even know what it looks like. So that's my evidence in respect of count number 1. In respect of count number 2, I wish to state this as an opening address. I've read the complaint many times. The representatives of the complainant are here, and I am simply, I don't know, because some of the things that are in your terms of reference are not in the complaint. I don't know who the complainant is. I know we are running for time, but unless I have to put this on record, that I will delay because I will have to deal with things that are not in the complaint. I will give you an example. So the complaint has evolved. I don't know if the JCC was in possession of information or documents that were not or are not in the complaint itself. There's an issue about the very first one of all the cases at Brasa, she's paid special attention to CIA matters. The issue that I terminated the mandate of PRASA attorney and personally appointed an attorney. I have not seen this in the complaint. If I'm wrong, someone will have to point me to the relevant. But I have noted that when the first witness was called, can't remember whether it was the first, and Ms. Maduaslev did ask about the other cases that CIA is being compared with, and the answer from the pro forma prosecutor is that they are only concentrating on CIA matter. But then you cannot say of all the matters at PRASA, she paid special attention to CIA, and you don't bring in the evidence of other cases. That's because it's not even in the complaint. But in my answer, my representations to the JSC, I have, in trying to answer this, that I'm even aware it's not part of the complaint because it's so vague. It doesn't say which matters did I neglect. I listed a lot of activities that we got involved in, and personally I was involved in. I should not even have done that because there's nothing that says I neglected this or other cases. So I'm saying in terms of the second charge, the issue, some of the issues raised as a sub-paragraph or sub-complaints are not even in the complaint. But be that as it may be, may I beg leave to just if in some of these bundles, I have attached a copy of the complaint that I laid against Advocate Botes SC, and the reason I'm mentioning it is that I have dealt extensively with circumstances under which CIA claims were settled in that document. So I just want to uplift it from wherever it is, if someone can help me. That's basically my evidence.
No, we appreciate what you are saying. You say your interaction with PRASA is contained in an affidavit which you've handed in either at the Zondo Commission or to the JSC, and you are now looking for that document that emanates from you. Is that what I'm saying?
Yes, it's a statement in support of a complaint, because wherever...
No, sorry, when you say a statement could be made by anyone. Is it the statement which you made?
Yes.
In response to a complaint involving the personnel at PRASA.
I was making a complaint.
You were making a complaint.
Yes,
And
against Advocate Botes SC.
oh, I see. You're looking for
Yes.
your complaint, which you must have submitted to the
To the Pretoria Bar,
Pretoria Bar.
Yes.
Is that what you're looking for?
yes. It's attached to my representations to the JCC, also my representations to the JSC. It details how I met Advocate Botes, what transpired between us until the settlement of the claims, and also post that up to when the legal team obtained a rescission of the arbitration awards. It deals with everything. So I just want to refresh because I'll be referring to the annexures in that statement. I apologized. I'm not.
No, you don't have to apologize. We'll
Proper.
just have to find what it is you're looking for.
Yes.
Just give me a minute and let me see what I can do to assist you in this regard.
Chairperson, we've managed to trace volume 19. From page 5, it deals with the statements in support of referral for investigations of possible breach of professional ethics, Botes SC. And it's got the various attachments there too as well.
Thank you. It's
Volume 19.
Volume 19 from page 5.
I find it here. Look at this. My volume 19 is upside down. I want to, maybe I'll find it somewhere else where it's.
Would it suit you if we take the long adjournment now?
Yes, please.
We will then adjourn now. It's 20 to 1, and we will reconvene at 1:45. Would that suit you?
Yes.
Yes, then we
Thank
stand
you.
adjourned until 1:45. Yes, Judge Makhubele, we can continue.
Thank you, President, and the members of the tribunal for the indulgence. I managed to find the statement, but unfortunately, there are no annexures. The statement is attached to my representations to the JSC, my representation to the JCC, but the annexures that are referred to in the statement are not attached. For our purpose, we may find the statement in volume 19, from page 3, it's 35 pages. What we've been doing was to try to locate the annexures elsewhere. I have forwarded them, or I forwarded them to the Secretariat so they can print. Apparently the printer is very slow. They informed me they are doing their best, but it will take time. But I believe by tomorrow morning, the annexures will be available. The evidence relating to Mr. Botes and my complaint against him is central to the issues mentioned in the last part of charge number 2, being negotiated a settlement relying on non-existent concessions, frustrating efforts to resist enforcement of the arbitration awards. Advocate Botes SC, or rather, the attorneys for the liquidators, because the company was under liquidation, approached me first through Advocate Botes SC around the second week of November 2017. He called me. I was in court. I could not take the call. I sent him a message that I would call him later that evening. I returned the call. After the greetings, he told me that he heard that I was at PRASA and I was chairperson of the interim board. I confirmed, yes. And he started to tell me the story about the matters where he's involved in a dispute, is representing the liquidators. The matter was supposed to go to arbitration, but that PRASA was adamant that they must go through arbitration, although there was an insolvency inquiry where the issues had been, or rather, PRASA witnesses had admitted that the claims were valid. So the liquidators, or the attorneys representing the liquidators and himself, had tried to speak to PRASA through its attorneys that they must look at the transcripts and obtain instructions from clients whether they really wanted to go on arbitration and what the disputes or the remaining disputes were. I said to him, I cannot talk to you over the telephone. If there's anything about PRASA, you better come to PRASA. We made an arrangement that he will come. Indeed, he came. I'm just trying to look at the date when he came. He found me with the then acting group CEO, Mr. Zide. I'll find the date. Yes, I have it here. 13 November 2018. I was with the then acting group CEO. We had just concluded several meetings, and we were sitting in a boardroom waiting for Mr. Bottas. I had a conversation with Mr. Bottas. He then gave me a copy of the report of the Commissioner Kreche. Attached to that report was some email exchanges between him and Mr. Madimpe Mukhashwa. I think he has attached them to his affidavit, also in volume 19. If I can. Page 65, volume 19. That's the Commissioner's report. Attached to it was email communication between him and Mr. Madimpe Mukhashwa. You will find that in the same volume, page. There are two pages. It must be page 76 and 77. The emails actually go up to page 81. Mr. Zide made copies of these two documents. And then we made arrangements to see the legal department. I just wanted to check the date, if the meeting was on the same day.
Sorry, Chair, Judge Mushidi. Advocate Makhubele, I think we have gone through that report extensively when you had legal representation. That's the report in which certain employees of PRASA gave evidence to the Commissioner. Some were ex-employees, some were current employees, and some made admissions about owing money to Yaya, and some did not. Is that the report? I just want to know if you intend to go through all of it.
Thank you, Judge Mushid.
I just want to know what point you want to make out of that.
Yes, thanks, Judge Mushidi, for the guidance, because in my mind, again, I'll refer to the complaint as well as the JCC decision. As far as this issue about the report is concerned, they say, at first they were saying the report doesn't exist. Non-existent report, and then it evolved to non-existent concessions. So once the existence of the report is established, and also that from a reading of that report, there are concessions, I thought that would be at least some evidence that would discount that part of the allegation. I am under your hands because I don't understand the complaint or the JCC's recommendations to be saying we must now, sitting here, go into whether that concession would have if they had gone to court, that concession whether would have sufficed or not, but because the issue is non-existent. But I heard when the witnesses for the complainant testified, they took about 3 days going into the merits of the report, which is not what I have been called upon to answer.
Again, for the record, Judge Moshidi here, the only dispute I remember about the report and those concessions was that it was never made available to the legal department at PRASA. And I think even including the external attorney, Mohasho or somebody, that they never saw that report. They were just referred to certain concessions made by PRASA employees, but that you as the chairperson of PRASA never made it available to them. That's how I understood the evidence in that regard.
I seem to recall, particularly Ms. Ms. Ngoye, saying she has never seen the report. But then, my evidence is the report was provided. This one was just a summary of the commissioner. There's a detailed transcript of the proceedings over 2 days, where it shows clearly that PRASA was represented by the same Mr. Mukhashwa and Mr. Tsatawani, Advocate Tsatawani SC. And I think Advocate Botes in his email that I've just referred to, he does speak about that report in his email to Mr. Mukhashwa. That was in September, 6 September 2017. And now we're talking about November 2017. So the allegation that they did not see the report is not true. I was sitting with the then acting GCEO, Mr. Zide. He made copies, and he called the legal team, both Mr. Dingiswayo and Ms. Ngoye. We spoke about the matter, which I then followed up with a memorandum. It's in the record. In that meeting, just after Botes had left, they then said they were going to make investigations. And subsequent to that, the whole bundle, that's the whole inquiry, insolvency inquiry, was made available. Because there was no direct contact with me that I can say, call her or rather Ms. Ngoye and say, yes, the report, the documents go through the acting group CEO, Mr. Zide, who then gives them to the documents to them. And they were able to respond. So if I am to talk about that issue, I'm glad to talk about the issue of the marginalization of the legal team. The alleged marginalization of the legal team. When I requested a report from them, being the legal team, they couldn't provide any status of the matter. They referred the matter to the external attorney. I never met. They promised to bring the lady that was working on the matter, one Mukotedi, but between them, the two, Ms. Ngoye and Mr. Dingiswayo, did not have knowledge of the matter. And that was a concern for me, even to the acting GCEO, that how can a matter like this reach this kind of stage when you don't even know what's happening? So that's how it started. After the reports were submitted, as we have heard, the witnesses, Mukhashwa, and detailing the reports and the plea, the bare denial pleas that were filed without even consulting the witnesses. And he only consulted with the witnesses when they were going for the inquiry, the insolvency inquiry. And at the inquiry, they made certain undertakings besides the concessions that they were going to do further investigations. Thereafter, you have seen the report of Mr. Baltek, who Ms. Ngoye said She said something along the lines that she has never seen that report. Sonic Baltek is one of the witnesses who testified at the inquiry, and he was a project manager. He was the person that knew about what they were talking about, and he was tasked to go and him and Prasa to do further investigations with the owner of the company. And in the report that he wrote, that's in this record, he was told not to cooperate with the commissioner, or rather to respond to the request of the commissioner. Ms. Ngoye claimed here that she was not aware of Mr. Sonic Baltek's report, and she was asked a question by the tribunal. Had you seen this report, what would you have done? And her answer was simply that, had I seen it, I would have looked at the matter in a different light. So here I am today, facing this tribunal because people chose not to read documents. They called the reports non-existing, and the relevant report of their own employees, they don't even look at them, and when they come to the inquiry, they claim that they have not seen their reports, knowing very well that if they had seen their report, maybe the charge against me would be something else. Not to say we relied on non-existing report or non-existing concessions. So back to, I'm responding to a question. The president asked me last week that I must talk about what happened between me and Ms. Ngoye. Can I start there? Thank you. We started off very well. She even arranged for me to meet the entire organization in some, I don't know whether it's I'll call it a hall or a boardroom, but that can fit everybody in that works in that organization. She went down with me and everyone else, and she introduced me to the entire staff. We were all very excited that we were going to work together. My experience, their experience, we were very happy. It's just unfortunate when I read Mr. Dingiswayo's affidavit, he says the first time I saw them, I asked about Siaya matter. That's not true. We had a conversation as colleagues because I think my first week we went to Parliament, and Parliament wanted a report about many things. So I met them as the legal team. We sat, the three of us and the acting group CEO, and between the three of us, me, Ms. Ngoye, and Mr. Dingiswayo, we got to know each other. I asked her if Ngoye is the same as Ngoyi, like in Lillian Ngoyi, and she said yes. And she told me how it came about that she uses Ngoye. And I was very happy to be working with them. The same with Mr. Dingiswayo, because if you know African history, you know King Dingiswayo. So that's why I say we started off very well. So we were in the process of compiling information that was wanted by Parliament from their own, that's within their repository. Then this Mr. Botes came. So it's not true that the first time I saw them, I started asking about CIA claims. We had a plan of action on what we were going to do about the matters that were Parliament was asking and about the state of the, what they were doing in the legal department, their challenges and everything that can be. I just want you to give me a minute. I just want to read from my notes of our first meeting. My first meeting with them, sitting down to talk about the state of their office, according to my notes here, it's 9 November 2017. Amongst things that Parliament had requested was the report about the appointment of Werksman's attorneys. And we talked about that, what they would be, how they were appointed according to them. I mean, Ms. Ngoye and Mr. Dingiswayo, they took me through how it happened and how matters came to a head. So we were doing something. And they also discussed with me issues about procurement, the supply chain and everything, and many other issues. That was one of our first meeting. And then the second meeting is when, according to my note here, Ms. Ngoye, 14 November, that's the day that Mr. Botes came. So you can see we had already started to work on matters that needed to be attended to. That's our first meeting. Thereafter, after they had written the various reports, and Mr. Mukhashwa, when he came to meet with me and the group CEO, I would often ask, where is the legal team? And the acting group CEO would always give an excuse for them, whether, I don't know, between him and them, but I remember one that's recorded in an email. I will make it available, that at the time, I think Ms. Ngoye there was a bereavement in her family. Another time there was the legal team were not available because there was a party in their department, something like that. So I didn't think anything about it, that I'm pushing anyone out or someone is busy planning to make up a story that I sidelined them, because the invitation for meetings would go through their colleague. And whether or not he told them, I don't know, but in these 2 occasions where I say there are emails, at least I can testify about it, that what I was told is that they were committed. So it's not correct that I marginalize them or anything like that.
Well, for purposes, Judge Mushidi, for the record, the purposes of this inquiry is really to respond to their allegations. Well, the first thing you did when you came there dealing with these matters, you paid special attention to the CIA matters. Is that true or not? I think we had them over and over again, saying that you had great interest in the CIA matters only. Did that happen or not happen?
Thank you, Judge Mushidi. Maybe because it's not just that I paid special attention. It's preceded by something very important.
Sorry, in fact, before we even go further, when you spoke about Advocate Bottas, did you know that he was counsel for the CIA group?
Before he called me?
At that stage, yes.
No.
And his instructing attorney was Matopo attorneys. Do you remember that?
No, I did not. I will get back to my dealings with Mr. Bottas, because it became a subject matter of the court, rather the High Court application. But then I didn't know Mr. Bottas was involved in this CIA matter. He was representing the liquidators or anything. I knew nothing about what he was doing. Yes, he's my colleague. I've mentioned in my documents that I've known him. He joined the bar before me. He is someone who has always been in the bar council. And when I joined the bar council, we worked together on bar council matters. Over the years, we've never worked together or against each other. I have no idea what kind of work he does. We are not friends. That's why I was comfortable when he alleged that I called him to say, here's my phone, here's our communication, and you can see before him calling me on 21 November, our last communication, you'll see from the WhatsApps that I'm going to present to you. Our last communication was in 2016, so I knew nothing about him. I only heard about it when he called me. Thank you. I wanted to say that should be prefaced with what it says here. It says, of all the cases that PRASA was involved in, she paid special attention only to those of CIA. This is how it's. So there are many cases at PRASA, and I paid special attention to this particular one. And I don't know which other cases they're talking about, what special attention is. I have replied in my, or answered in my representations to the JSC, attaching evidence. You know, when you're answering a question in the wild, you don't know what all these other cases are. And then I showed what I have done, what we have done. There's not even one matter that Martha Ngoye or Fanny Dingiswayo referred to me or to the board that we ignored, where that would be a starting point to make this kind of allegation. But I heard the pro forma prosecutor that she's only concentrating on CIA. So I think they'll need to, I don't know how this part of the, your task is going to be handled, but there's nothing to gauge that I put 10% on other matters or and 80% on CIA. If you have looked at all the evidence that I've attached, you would be surprised at the energy that I have put, even more than on this CIA matter. I am a person that likes to keep record. You must have seen all my memorandums and everything. So as far as I'm concerned, there's nothing that I must gauge against, or you will be able to gauge against, to say she only put 10% on all these other matters. We don't even know how many matters that PRASA was involved in. And I heard when the pro forma prosecutor answered a question about what these other matters are, that she's only concentrating on CI. So this, to me, really, I'm being called to answer something that they don't even know what it is. And I heard someone suggesting that it refers to matters in litigation. That's not what it says here. In your terms of reference, there's nothing about litigation matters. It just says of all matters that PRASA was involved in. So I don't know if I've answered your question. I've rounded about up and down Judge Mushidi to say I have placed evidence, even though this allegation is vague. But for you to make any determination, you'll have to go back and ask the complainant to give you a list of all matters that PRASA was involved in that I ignored, and then you will be able to say she only worked on CIA matter. And you know, I think because things that are written in this complaint become subject matters of news reporting. Some will say the only thing I did at PRASA was CIA. But you've seen evidence, and if you have time, I can take you through. Thank you.
Judge Mushidi, again, for the record, you will recall when Ms. Martha Ngoye gave evidence here initially, I questioned her extensively about their statements in the file and all the PRASA employees, and I wanted to make sure that there was no made-up story or plan to get you into trouble unnecessarily, or collision between them, because before she gave evidence, we went through their statements, and I questioned her here very extensively. But on this question of CIA, of you paying special attention to those matters only, it doesn't stop there. It goes further. The evidence is that the CIA matters were even settled secretly at your instance without involving them. You recall that evidence?
I do, Judge Mushidi, and as I say, the complaint keeps on evolving. That was even what was said in the High Court application, that there was a secret settlement, and you've heard the evidence of the attorney, Mr. Mukhashwa, that he denied that he was part of any secret, him or his firm or anyone in his firm was part of secret negotiations. And if something is secret, why would I leave paper trail? I mean, if Botes, or rather when Botes approached me and we wanted to be secretive, we wouldn't have involved anyone openly. I wrote memorandums, I called for reports. Mukhashwa attended to my offices. I even met them, Ms. Ngoye and Mr. Dingiswayo, and they knew what it was all about. And for them to come and talk about secrets, I really don't understand. So I deny that there were any secrets. They were invited. They chose to stay away. And the fact that they chose to stay away does not make things this secret or unlawful, because she says, I think it's Mr. Dingiswayo, you'll pardon me if I touch on this and that evidence, it's because I'm answering to your question. Mr. Dingiswayo says the authority to settle claims lies with Ms. Ngoye, and I dispute that. Up to where you are seated now, you don't have a delegation of authority. You don't have that. We as a board wanted to see that authority. You see there are letters that are on record calling on her first to produce anything in writing that gives her that kind of authority. There's none exists. It's only between her and Mr. Dingiswayo. You will recall, my evidence is, when we started, the secretariat who is responsible for providing documents, in our first meeting we requested for that delegation of authority, and we were provided with a document which is in the record by the secretariat, Martha Kotu. By email, it exists in the record. I will unearth it. That's the only delegation of authority that I know. The one that Ms. Ngoye whipped out, I saw it first in the High Court application. There's no record that delegation of authority that she has presented to you was ever given to the board. And there's no record. So, according to the delegation of authority that was given to the board, she does not have power to settle that, a claim of that magnitude. That power lies with the acting group or rather the group CEO, acting or permanent, and which is why I said in my evidence that that's the person that had the authority, not Ms. Ngoye, but involving her is because, let me start here. Ms. Ngoye is the head of a unit called Legal Risk and Compliance. She's the executive. She's, of course, she sits in the EXCO and would be entitled to make decisions pertaining to her unit. And it has also been explained to you that Mr. Dingiswayo is the general manager who's dealing with litigation. And the attorney that this matter was allocated to is Ms. Mukotedi. Yes, there would be claims within her her power of a delegation that you, but not this particular one. So you are sitting there with two delegations of authority, one with proof that it was given to the board because there's a record, there's an email from the secretariat, one that first surfaced when Ms. Ngoye filed an affidavit at the High Court to say she has that delegated authority. But then delegated authority does not only exist in that document. There must be something writing to each and every executive or each and every person. So we're still looking for that, for her one, and because she kept on saying she is the one, she has that authority, but I don't know where it comes from. She could have simply brought it to you here to say, here, in terms arising from this delegation of authority, here is my authority signed by this and that CEO, but you don't have that. Thank you.
Well, Chairperson, Judge Mushidi, I don't want to rush you and your evidence, but for purposes of this tribunal, you want us to accept that all these witnesses, about 4 of them or so, they did not know, in the first place, they didn't know you when you arrived at Prasa in 2017, is it? They didn't know you before that, did they?
Thank you, Judge Mushid. I didn't finish. I talked about us starting off well. I'm still going to talk about where it went. It went south. Can I?
I recall they seem to have testified that they were in fact happy to have a chairperson at Prasa who is not only initially there as senior counsel in private practice and also a potential judge of the High Court. So they were very happy to work with you and to be with you. But now you say we should not accept their evidence about how you interfered with the CIA matters, how you settled them behind their backs, and how you sidelined the legal department, dissolved the external panel, and also telling the external attorney, Mr. Mukhasha, not to talk to them at all. I mean, it's that, and that they are lying against you, all of them, that you're just making up the stories against you. Is that what we must accept in sort of summarizing their evidence against you as to what happened at Prasa since your arrival?
Judge Mushidi...
Is it too simple, the way I put it? I mean...
Judge Mushidi, I think to be fair on me, if you can allow me an opportunity to, because I say I was given a reason why they were not attending meetings, and I accepted that reason. And as for, I'm being fair on them, although Mr. Dingiswayo concocted a story that the first time I saw him, I asked about CIA, which is not true. There's a record. But I think Ms. Ngoye doesn't go along with that. She acknowledged that we started off with some other things before CI. But then, after we did not see them, that was the last time they cooperated with us. Remember, there was that issue of suspension of the legal panel by the board on 1 December. That was the last straw. They were no longer visible, if I may use that word. So the fact that we started together, it didn't end there. The honeymoon or the happy relationship to be built, it didn't even fly, because we started, there were hard questions that were coming from me and the board on things that we wanted from them. I can give you a list. There's the Velksman's appointment, there's the legal bill, there are so many other things. The suspension of that legal panel, that was when they, I don't want to accuse them, after that, those resolutions of the board were leaked, and I met Ms. Ngoye. We were preparing something that was supposed to go to Parliament in the boardroom where we were having lunch, and I had a conversation with her. That's when we formally, I think she formally drew the line. I talked to her, I said, look, that resolution of the board that was leaked to this hashtag Unite Behind, don't you think you should withdraw it? And the memorandum that she had written to the board, because look, now the organization is using it to go to court, and there are newspaper reports that you have written, the board, this kind of memorandum, why don't you withdraw the memorandum? And she becomes visibly aggressive towards me, and that was the end of our civil relationship, Judge Mushidi. So it's not, I was starting to say, my first sentence was, we started off well, but somewhere it went, it didn't last, and because of many issues that I'm mentioning, I do not remember, and I have never, Mr. Mukhashwa, whenever he came, the arrangements would be made by the acting group CEO. I've never picked up a phone and speak to Mr. Mukhashwa, and I've never told anyone not to speak to anyone, because in the meetings where excuses were given, he was there. I would ask, but where is the legal team? And Mr. Zide would give excuses. So why would I be concerned about their whereabouts when I did not care, or I never gave him an instruction? And I don't remember in chairperson, rather President and Judge Mushidi, that was the evidence of Mukhashwa. I think it was the evidence of Mr. Dingiswayo. Mr. Dingiswayo said Mr. Mukhashwa told him that he was barred from speaking to him. I will have to check the record, but I would never do such a thing. And as for I think you mentioned 4 lawyers. I don't know who's the 4th lawyer talking about me. I don't know, but the 2 have reasons, and I will deal with all those issues that I've mentioned. The Werksman's appointment, the legal bill, the suspension of the legal panel, and Mr. Dingiswayo, there was that issue about his conflict of interest that had been picked up by the Auditor General. So this, obviously they were aware that being inquisitive as I am going to ask about some of the issues where there are alleged corruption or ineptness or negligence or anything would come about. I was bound to ask, and if I may mention, there's one, also other than the CIR people, there were others that approached us. I think I mentioned in one of the affidavits, I think it's the state capture affidavit, that Mr. Botes came again with another matter, the Siangena matter, and I told him straight that, look, this matter is in court. I'm not even going to talk to the board about it. There were many others that, you know, when there's a new team, people who feel aggrieved would want to have their matters. There's even one that who approached me and the second acting group CEO, it's SA fencing matter. These are people who had one of these disputes with PRASA about their contracts, and we sent him off. And I later learned that that's actually the matter where Ms. Ngoye is in trouble about. So obviously, if you look at all these matters and then you see their interest, they would be worried that this person is going to ask these questions and get to things that we think we have concealed. Thank you.
Well, Judge Mushidi, again, Chairperson, I don't want to belabor the point, but speaking for myself, we as a tribunal will then, after listening to you, have to determine, make up our minds whether these 4 witnesses or so misleading us and not telling us the truth. But let me revert then, now that you mentioned Advocate Porter's essay, on your own version, I think, on the papers and elsewhere, you knew each other very well. From the Pretoria Bar, you worked together, you were colleagues, you trusted each other, and I think you will recall, we asked him here that or even you indicated somewhere that he actually abused you. He abused the trust that you had in him. You recall that part of the evidence. And I even asked him, Advocate Portas, when he was here, that the interaction between him and you was rather extensive. You recall that. It was emails, texts, it was personal visits to your office, it was bringing a copy of the judgment of Judge Sandton to you. Recall that evidence. In other words, to say you were colleagues at the bar in Pretoria, but he abused your trust in him. He was acting for the CIA group and with his instructing attorney Matopo, and he gave information to other people without telling you.
Well,
And you'll also, sorry, before you respond, you'll also recall that I asked him, why did he go on so long interacting with you as chairperson of the board when he was acting for the opposition against Prasa? He abused you, and I think that was part of your complaint also to the Pretoria Bar Society. He took advantage of you, in other words.
Judge Mshidi,
Am I right?
the same way when counsel stands before you in court, you expect them to, you don't expect them to lie. You can take their word for what things are. The type of trust that between counsel is, as far as my experience is concerned, when we are in court, you can't behave in a manner that's unbecoming of a counsel, presenting hearsay evidence, forging documents, because that's what Advocate Botes did. I will tell you about it if you allow me. That's the letter that allegedly was from Matopo with pasted WhatsApps from me that was made to appear as though Matopo has made some formal inquiry. There was no such inquiry. Up to now, Mr. Botes or Advocate Botes will, when you talk to him about it, he will simply say, no, I showed my attorney the SMSs, and then my attorney decided to paste the SMSs onto a letter. Is that ethical behavior of a counsel? But to answer your question, we're not friends. We're colleagues. We know each other from having served at Bar Council, but that's where it ends. So when he came to Prasa and then he presented the matter and he followed through, at the end of it all, I realized that some of the things that he did were not conduct that one can expect from an advocate, and that's when I laid that complaint with Pretoria Bar to say, and he confirmed before you that he had, the reason he was doing the running around is because his attorneys had an agreement with him that he will actually be the person doing that. But and in my book, that's not ethical behavior of a counsel. You will see in the WhatsApps that I am going to present, if you allow me, early in our interactions, because I realized that he was now the one doing the follow-ups, attending the meetings, and I said to him in one SMS that please leave communication to the attorneys. This exists. I'll take you through the SMSs as soon as they are done printing them. And then I distanced myself from him. I gave him the number of the group CEO that if you want to make any inquiries about this CIA matter, here is the number. You and I should step back. After several days, he came back to me by WhatsApp, it's on record, to give me a report that he has met the group CEO. They've discussed the payment. The group CEO has promised him that he's going to make the payment. I was no longer there. I had distance. I said, you and I will need to move out of this thing because I can see that now we are overstepping the limit that council can do. But he proceeded, and he would want to get instructions. And when maybe your assessment of abuse, because that at the time when I sent that complaint, I really felt I was at my lowest with Advocate Botes. The many things that he has done. One thing after the next, and after forging that letter, he then, I don't know whether he then came to me, when a snake bites you and then offers to take you to its doctor.
Okay, sorry to
So he took
interrupt
me
you.
to
I
his
just wanted
attorney to say
round
the
off.
attorney is going to help me. And the attorney turned out to be the very attorney of the liquidators. And I only found out when I looked at the letterhead. I said, no, but this attorney I bought this is the same attorney. He's conflicted. And we had to get through a process of getting a legal opinion. That's what I'm saying, that the abuse maybe should be seen in that context, because when he does something wrong, he wants to correct it, and then he puts you in more trouble. He went to the State Capture Commission. I don't know whether he was invited or he invited himself, and then he said, I called him and asked him, what can I do for you? I don't know which advert that says that, but that's what it says. What can I do for you?
Sorry.
And I never said
Let me cut you short here and round off this point, because the question of the various emails and contact and interaction between you and him are on record. We have it in the bundles. And I will end up by asking you the same question that I asked him when he was here. But with you, first, when did you realize that he is abusing you? That is overstepping the mark of ethical bounds, and at what stage did you become aware of that now? Before you lodged your complaint with the Pretoria Bar Society of Advocates. And we know what the outcome of that investigation was, yes. And we know that you have appealed against that as well.
Yes.
But just very briefly to round off this point, at what stage did you become aware that Advocate Bottas is abusing you, or information that you give him, you give to other people who are not supposed to know about it, etc., etc., etc.?
Well, maybe not that.
And if you became aware, what did you do?
Maybe not that they are not supposed to know. The last incident, when I was, remember after I realized that the legal unit was resisting to pay, I stepped back, and the matter was being handled by the group CEO. And I was preparing to leave PRASA. I think a week before I left, I was on my way to Cape Town. That's when he called me. I didn't even know there was a court application. I heard from him. So he would go inside and get information and come and tell me. And I said, this is 8 March. That's when the incident, when I say he forged a letter, made it appear like there was an inquiry, and the inquiry was the response to those inquiries were those SMSs. And then that was the last straw for me. And I asked him, because I was not even aware, why did you do that? Because you know, number one, that I'm already out of that matter. I'm preparing to, on the day I was going to Cape Town to talk to the justice, one of the justice officials in Cape Town about policies relating to appointment of judges. You didn't tell me, number one, that you are asking me these questions because there's already a court application. And what I told you is in the public knowledge. It was already a public matter that the PRASA legal panel had been suspended. It was, from what I had heard, the affidavit in court was referring to me too. And I asked, as I was talking to Botes, I was talking to the acting group CEO on the side, that why did you not tell me there's an application in court? I have to hear from Mr. Botes. But unbeknown to me, Mr. Botes, when I asked him, he says, no, I was just talking to my attorney, and then we decided to use these SMSs as if there was a formal inquiry. And I said to him, I think we have reached a limit, you and me. Let's go and report ourselves. That's when you read my complaint, that's what I say. I say, let's go to the bar, because I was still a member of the Pretoria bar then. Let's go and report ourselves that this is what happened. You approached me, and then we got involved in this issue, and this is what you have done. And he took time, he delayed until I decided that I was going to lodge a complaint. But the original plan was for the both of us to approach the ethics committee, because there was a further incident. You have heard Mr. Dingiswayo talking about a circus in court, where the matter before Judge Holland Newterm, Advocate Botes stood down the proceedings because he wanted to fetch some documents that was not even before court, and a lot of hearsay information that was provided to the judge, resulting in the judge, well, in his discretion, deciding in the manner that he does. And that was the last straw. Then I said to him, let's go and report ourselves. He delayed, and then I reported to him. They didn't investigate the matter until he went to Zondo Commission, and then in fact, the matter, Pretoria Bar didn't even investigate, because they just wrote me a one-liner to say, I called him, I was not a judge, and the information that we were talking about, I never said it's without prejudice. But I think that was a wrong approach. They didn't have the information. They didn't invite me to respond to his answer, which I think I only saw at the State Capture Commission. So yes, I became distressed when to top it all, he went and lied at the State Capture Commission under oath. And no one says anything about it because it's Advocate Bottas SC.
Well,
Anyone
you've
would
been speaking
like-
for some time. Give me time to finish off. I just want to round up this issue. Chairperson Judge Mushiri, for the record. In fairness, I think I should ask you the question which I asked Advocate Bottas when he was here, that during the interaction with him, which we have agreed on record that it was rather extensive, unusual, did he ever, or did you ever realize that this interaction with Advocate Bottas, who's acting for the opposition party as a counsel, I am meeting with him, interacting with him so regularly, so often, without my legal department, without legal representation, without external or internal legal people, that did you not realize it's too wrong? He's acting against the interest of PRASA, where you are the chairperson. But here you are engaging extensively and talking about matters. You as Advocate Makhubele, SC then and now as judge, did you not realize that this interaction cannot possibly be in the interest of PRASA, my employees? I own allegiance to PRASA and also to the Minister of Transport, executive. I must report to the executive. But did it not occur to you at some stage, we all make mistakes, in hindsight it's easier to say, but didn't realize that talking to Advocate Bottas without your own lawyers, internal or external, about matters of PRASA, that could never be in the interest of PRASA at that stage? Or is hindsight the best?
Can I
After the
respond?
event,
Can I respond?
just briefly, really.
Thank you, Judge Mushid. I think when we say extensive, it's an exaggeration. It's an exaggeration. The incidents, I've already said, I'm looking at I think I'll have it in the morning. Early in January, when I told him that it's wrong for him to be making inquiries with me, he must contact the group CEO, and I gave him the number. And he's the one who made the follow-ups with the group CEO. And he would come back and report to me, and I would simply say, yes, thank you for the update. So after that, then there was that communication as I was leaving PRASA in those SMSs that ended up in court. So I can't agree that it was extensive communication. The meeting was once when he came to PRASA in the presence of the group CEO. That was in November of 2017. And after that, I never met with him again. So I can't say there has been extensive communication. You'll see for yourself when you look at the WhatsApps. It can be extensive. Maybe the gravity, if you were to say that, it can be one meeting that has severe consequences, but it can be, we can use the word extensive.
Thank you. That's from my side. That's all I want to hear in regard to count 2 against you in this matter. Is there anything else maybe that you wish to add to the second count that we're dealing with? That is your stay at Prasa
I still want
from 2017
I still
to
want
March
to
2018.
I still want
huh?
to testify. I was answering questions. I still want to take you through the issues. Let me see what I have left here. And what I can say is when you say the 4 attorneys, can they lie? They lied because they talk about non-existing report. They lied because they say non-existing concessions. So it can be, with due respect, Judge Mushidi, that their evidence against me is all good and they are. So I can't accept that, and that's why I say I'm still going to testify. They rushed to give information to Unite Behind to lay a complaint without first doing their homework. Because if they had done their homework, they would have found that the report that they say is non-existing does exist. They would have found out that the concessions that are said to be there, they are actually there. They would have found out that, for instance, Ms. Ngoye, she even refused here to look at the report of Mr. Baltak, which didn't just come from the sky. It came through the channels. It came through the channels to the acting group CEO, to me. If she had taken a time, she would have found that one of their own project managers, who was the responsible engineer, had written this kind of report, had testified about it. These are things that if they had sat down and reflected, they would not have, remember they are not the complainants, they gave the information to Unite Behind to lay a complaint. But the documents are there. Why didn't they request the documents? You will recall that the acting group CEO towards the end requested certain information from her, from Ms. Ngoye, and she flatly refused. If you've made a wrong assumption, why don't you agree to have a look at something that may probably persuade you? But because your mind is set at destroying this person, I must just send this information to Unite Behind, they must deal with her.
Thank you, Chairperson.
Thank you, Chairperson. I've got a question, Judge Malulek. As the updates were coming from Advocate Botes, and you realized that now he's no longer giving you the information that is in the interest of PRASA, you still did not believe it prudent to rope in legal, or am I incorrect to say that?
Well, thank you, Ms. Wesley. Legal was on the matter at the time. Remember, the settlements were in 2017, and beginning of 2018, when I was informed that there's some dissatisfaction from the legal department that they were not informed about the settlement. I then said to the acting CEO, let them do what they want with you. And I then informed Botes that don't let the lawyers handle the communication. And then then later on he asked for the telephone number of the group executive. I gave him the telephone number. I said, I'm no longer involved in this matter because there are allegations of wrongdoing. So I'm allowing the legal department and the CEO to deal with the matter as they want to deal with it. So he would, I don't know out of what, just after he has a meeting with the CEO, he would simply send me an SMS to say, I've had a meeting with that time it was Mr. Mulepo, with Mr. Mulepo. Mr. Mulepo says, PRASA should not waste money, they are going to pay the claim. And I would simply say, thank you for the update. But as to why I did not tell legal, because the matter was already in their hands with the group CEO.
Yes, while it was in their hands, what I'm trying to find out, the matter was in their hands, but you are getting another information, other updates, and these updates are not coming from your own legal. Would it not have been better to give them instructions or write memos that you were writing to say, this is the position, legal, attend to this? That's what I'm trying to, with the power that you had at PRASA.
Unfortunately, I'm responding to you without the benefit of those communication. But then when he told me, remember, legal was not telling me anything. I didn't even know that they had launched or they were planning to launch an application in court until that the matter has been set down for the 8th of March as I was traveling to Cape Town. So when I heard from Botes that the matter has been set down, do I know if PRASA is opposing? And I said to him, I made it clear in my reply to him that I don't know anything. I'm out of this matter. I'm no longer involved in it. And he then screenshot the notices to oppose. That's when I informed the acting group CEO. You'll see from our communication that I hear there's this information, and from the information that I've had, I am mentioned in the court application. I don't know the nature of mentioning, but obviously because I was part of that settlement, why was I not informed that there's this court application? And the group CEO and the company secretary, who was the first group CEO when I went there, they replied to me, you will see the replies, to say, if I'm quoting the response correctly, that I think it's Mr. Mulepo said that was the decision of Ms. Ngoye. So I was not getting anything from legal. And when I asked the acting group CEO, he simply said that's the decision of Ms. Ngoye, and then they insisted that they want to utilize those attorneys who are, remember the issue was about the attorneys who were not in the panel of SACA, which will still come to. So it goes two ways. Honorable members, if I may say it. There's nowhere in the evidence before you where Ms. Ngoye and Ms. Dingiswayo expressed their what I would call frustrations or suspicions about me, because these are experienced people. They know there's the board. We were there, all of us, and if not formally to the board, that would be the first option, of course, to write to the board to say, we see this kind of thing happening. And then that's for the period until Minister Nzimande was appointed in March as I was leaving. So from November 2017 to March 2018, there's nothing. They never raised anything with us. And in the meantime, they were busy feeding information to the complainant. So it can't be one way. If there's something that they are not happy with me, they should have told me. It's only when they wanted to, they went to Minister Nzimande in March of 2018 that they wrote to the board. They wrote, I think that email that was sent to Minister was copied to the board, or they sent an email to the board to say we have this issue. So I can't imagine how I'm supposed to know that someone is not happy when I'm not told that there's this unhappiness. I'm not told that this document you talking about, we don't have it, can we have it?
Just to be fair, it's common cause, isn't it, that Ms. Ngoyi and the others in the legal department at PRASA, from the 1st of December 2017, was suspended from dealing with this PRASA matter. Is that correct or not?
Pardon, what was...
They weren't involved in the PRASA matter from the 1st of December 2017. PRASA and CIA.
The staff.
Yeah, the staff. The legal department at PRASA, which included Ms. Ngoyi, she said that she was told that she shouldn't be involved with CIA and the board, so to speak. The board would get its own private attorneys to deal with the matter.
I'll have to review I don't remember that she was told she shouldn't be involved. What I remember is the evidence of Mr. Dingiswayo that they were told not to speak to them. I don't know about what, but just to don't talk to these people. But that
well, just before you go on, just before you go on, let's just stop there. Dingiswayo was told not to talk to them. Yes or no?
I didn't tell anyone not to talk to anyone.
Who gave that instructions?
I don't know, President. Certainly not me.
It was you who gave that instructions, or wasn't it you?
President, you're saying I gave the instruction?
No, I want to know who. I'm not saying you.
I say I did not give any instruction. And if you follow my mode of operation, I write. If I wanted anything to do with this matter, I would write to the acting group CEO and I would get a response. And I never told anyone because that, if he told them that I said I don't want to talk to them, then that's, I don't know, someone must answer because it's a triple hearsay.
Yes, thank you. Yeah, carry on. Are you moving on to something else now, Judge Makhubele?
I was not on anything. I was answering questions from the tribunal.
Yes, no, I
so
understand.
I need to get my bearings where I want to be. I don't know if we can adjourn. It's already to 4. I need to, tomorrow I must bring, my attorney tells me her printing facilities not up to standard, so I must make copies of documents from my home printer and come with them. So I need to get to home before, because once it's 4 o'clock, I will get home at 7 o'clock, and I will be tired. I won't have time to do anything.
Well, you didn't have to argue for an adjournment. All you had to do was ask for it. Yes, we will adjourn until tomorrow at 10 o'clock.
Thank you.
Yes, we stand adjourned.